So let's talk a little bit about pretrial matters. And again, these are some tools that you can use before trial to essentially back up your case or potentially push towards settlement. So depositions used to be, no one really did these in tax court because the tax court rules didn't particularly favor them. But that's actually changed, and now it's easier to get depositions. And so you can use a deposition. You can interview someone essentially on the record, under oath, before trial. And you can admit it. You can admit it in the actual court proceeding for various different reasons. So if the person has passed away, then you can actually admit it potentially as their testimony. If they're located very far away or out of the country, or they can't attend due to health concerns, you can also potentially use that as their testimony. But more importantly, you can impeach them. So if you have a witness, an IRS agent on the stand, and maybe you deposed them a couple months ago, and they say something different at trial, you can use that to say, well, which one's correct? Why are you saying something different than what you said before? So a deposition is also a way to do discovery. You can interview essentially on the record different parties and get to the bottom of what they would say in court, right? And you can gather evidence that way. And then once you know what they're going to say, you might have document requests or other requests that follow up on what they've told you in a deposition that you get in advance of trial. In order to have depositions, you must serve notice on every party. And the parties may object within 15 days of service. So if you serve a notice on the IRS, on an agent, they can object to that based on different grounds, privilege, relevance, scope, within 15 days after service. Can be written or oral. Generally, depositions, it's highly favored you do it orally, so in person or over the phone or video, doing oral questions. But in certain circumstances, like when a party is in a foreign country or there's a language barrier, sometimes you can do it by asking a series of questions in writing and then the person responding in writing, but that's not the normal case. Administrative summonses, these are the typical summonses you see in exams. So when the IRS issues an IDR, information document request, and a taxpayer doesn't respond, they can do what's called an administrative summons, okay? Now, generally these aren't used in tax court because tax court has its own discovery methods and the court doesn't favor necessarily using the administrative summons process as a discovery tool in lieu of the tax court discovery methods. But on the other hand, it can be used against the taxpayer. So if the IRS issues administrative summons, they can do so if it's before the tax court petition is filed. And they can use that information that's received in response to that summons during the trial. Okay. Now, if the summons is issued after the taxpayer files a petition in tax court, they're not generally allowed to use that information, that whatever they get back from the taxpayer, in the tax court trial because they're supposed to use the tax court discovery methods. There's a couple exceptions to that, and that is if it's the summons was issued after the petition to a third party, or it's for a year that is not part of the tax court case. In other words, it's for a different year than the year that's before the court, or the years that are before the court. So I also want to touch on motion to compel here. Motion to compel is basically if any of the discovery tools that I've talked about before, interrogatories, requests for production, requests for admission, depositions, if one party isn't complying, party's basically not responding, the other party can file what's called a motion to compel. They can do that all the way through the discovery period, but they have to do it at least 45 days before the start of trial because, of course, the court doesn't want to be resolving these motions to compel while they're preparing or going through trial. So a party, let's say, who didn't get answers to their questions can file this motion to compel. The party that's resisting the motion to compel must make objections in response to the motion to compel. Raise privilege, raise undue burden, raise lack of relevance in the question. They got to do something because failure to respond can lead to contempt of court, which can involve serious fines and professional liability issues, or various other punishments. So the court could order that certain facts that were requested and not given are deemed admitted. They can preclude the party from introducing evidence, the party that didn't respond. They can strike out certain parts of one of the party's pleadings, like the answer or the petition. They can stop the proceedings until the party responds. They can dismiss the entire case or just give a judgment in favor of the other party. So lots of bad things can happen if you basically don't respond in discovery and the other party files a motion to compel and you don't respond to it. So if you get a motion to compel, you have to respond just in some way, shape, or form. All right, so let's talk a little bit about trials and appeals. So when you're headed towards trial, the court and all judges have that standing pretrial order, and what it requires is a trial memorandum. A trial memorandum is basically you're telling the judge, here's what's going to happen. We're going to try this case. We're going to call 1, 2, 3 witnesses. We're going to call maybe an expert. And here's what the witnesses are going to testify about. It's giving the court a written summary of what you're going to show in your case when you try the case, or what the taxpayer is going to show when the court starts. Now, there's a lot of debate in the sort of tax bar and among tax practitioners about how robust your trial memo should be. Some people take the view, don't put anything in it, because you don't want to give the other side a preview of your case so that they can sort of prepare a response. On the other hand, a lot of practitioners will say, well, no, you want to prime the judge. You want to be the first one to give the judge a concise description of the case and a good summary of the case. And frankly, that's generally how I tend to go, is you want to be the first one to give the court a readable, understandable, clear and concise explanation of the case and what you're going to prove, because you're helping the judge to be prepared, and judges tend to like that. And so I would say go on the more robust side of the trial memorandum. But again, it is a tactical call. The calendar call, again, that's when the case is called for trial. Doesn't necessarily mean that's when the trial will actually happen, but that's when the court calls the parties up and says, okay, are you ready to proceed to trial? Have you reached settlement? And we'll set the actual specific time for a trial. One thing that's important to know is who has the burden of proof. Remember that generally speaking, the taxpayer has the burden. In other words, the IRS's determinations at the administrative level are presumed correct. It's not true in all cases, but we're talking general deficiency tax cases. That's true. Penalties, it can be different. But for most cases, the taxpayer has the burden. Now, the taxpayer can shift the burden of proof to the IRS under Section 7491 if, again, they've complied with all substantiation requirements, they've introduced credible evidence, they've maintained all required records, they've cooperated with the IRS's request for witnesses, documents, meetings, interviews, etc., and they're below a certain net worth requirement, which is in 7430. So in that case, if you can prove all those things, basically you cooperated with the audit and you have credible evidence for your position, you can shift that burden of proof to the IRS. Now, in practice, I will tell you, shifting the burden of proof doesn't usually decide the case, because most cases aren't so close that they're decided on just, okay, well, one party didn't quite meet the burden of proof. The courts don't usually decide cases on that basis, but, you might be the one exception. And so sometimes it is useful to see if you can shift the burden under 7491. In terms of evidence, the court does follow the federal rules of evidence generally, although it is more relaxed. And so remember, when you're going to put a document in front of a witness, you have to mark it as an exhibit and put it into evidence so that the court can consider it. One thing you can also have are demonstratives, visual graphs, charts, things like that aren't evidence themselves. In other words, they're not a contract or a tax return. They're not a piece of evidence, but they summarize or visualize actual other evidence. And those are admissible in the tax court. You should probably you should share them in advance with the other party to make sure the other party is amenable to it and won't object to it. But you can use those kind of things in court. And then remember, there's always going to be, not always, but in most cases, there's going to be a post-trial brief. So the court will ask the parties to file briefs explaining their positions in writing after the trial of the case. Now, after the trial of the case, the court will issue its opinion. So they will basically say, here's what we think. They will explain their reasoning. If you don't agree with it, the taxpayer or the IRS, they can file what's called a motion for reconsideration. The motion for reconsideration basically says, hey, court, would like you to reconsider your decision. Would like you to basically change it. In practice, does the court often grant these? No, not usually. Generally, there needs to be some kind of new evidence or some clear error that came up in the opinion that results in a motion for reconsideration by one of the parties. And you've only got 30 days after the opinion is issued to make a motion for reconsideration of the opinion. After that time, the decision is going to become final. Once the decision becomes final, the taxpayer has 90 days to file an appeal. Okay, so they've got 90 days to file an appeal, which would go to the U.S. Court of Appeals in the relevant circuit, or if it's in the Court of Federal Claims, the federal circuit. All right. Remember though, once you file an appeal, collection is not stayed anymore. So remember, collection is stayed while the tax court proceeding is pending and during the additional 90 days where the taxpayer can file an appeal. But if the taxpayer decides to appeal an adverse decision of the court, the IRS can start collection activity unless the taxpayer can post a bond for the amount that is due to basically delay collection activity. So if you lose at the tax court and you file an appeal, you just got to warn your client. They may have to face IRS enforced collection activity. And then finally, in these cases, the IRS, if they lose in tax court, they will sometimes issue what's called an acquiescence or non-acquiescence, meaning we agree with the tax court, we lost this issue, all done. But oftentimes you see it where the IRS is saying, look, we disagree with the tax court, we're going to continue taking a position contrary to the opinion, and it's warning taxpayers to say, if you take this position on your return, even though this is a tax court case that says it's okay, we are going to litigate against you, or we're not going to accept that decision of the tax court. And so it's sort of a beware, even though you got this favorable decision, we may still fight you on it. All right, so with that, let's go to our review. So we've talked about the background, we've talked about the tax court versus different refund forms, we've talked about going to court, what you need to do to get there, again, making sure you file in that 90-day window to get that petition in before the notice of deficiency 90-day period expires. Talked about pretrial practice, so what you need to do as you get ready for trial, and again, good pretrial practice, following the discovery, getting lots of information from the IRS, asking questions to the IRS. Those can all result in settlement because sometimes those questions lead to documents that maybe the agent had some doubts about the merits of their position, or maybe there was some dispute. Maybe they don't have the evidence they think they have, and so oftentimes that can lead to settlement. Pretrial motions, pretrial matters, again, you want to brief the court. Do what you can to make it easy for the court to decide in your client's favor. So give them as much information as you can ahead of time before trial to make it easy for the judge to try the case and decide in favor of your client. Then, of course, trial and appeals. It's always a little bit of the Wild West when you go to trial. You never know what's going to happen, but that's where you really want to have someone who's done it before help you and advise you in that trial setting if you get to that point.
Alrighty, and with that, we'll wrap up. I want to thank Josh for being on today, and we appreciate you coming. This has been a lot of good information, and I'm sure we can have you could spend lots and lots of time continuing to study tax court. Just one thing, and we'll look kind of the last part. People contacting you if they have questions or or concerned about maybe they're going to tax court or have someone to refer. What's the best way to get a hold of you?
Yeah, so there is so much we couldn't cover in sort of the overview today, but if you do have any questions, feel free. My email is right there on the screen. It's josh.wu@strasburger.com. I'd be happy to chat with you about any questions you might have.
Perfect. Thanks so much. We'll look forward to seeing you on a future webinar. I want to thank everybody for taking the time, and we will talk with you soon. Thanks a lot.